Okay, so good afternoon everybody, welcome to the Data Protection Update webinar. My name is Ben Kane, I'm the Certified DPO for Fusion Business Solutions Limited and Staff Absence Management Limited. So a couple of things we're going to go through today, just some general updates, a little bit of an overview of where we should be at with certain things, cover a couple of the common subjects that I often face or I generally get asked about by schools themselves. But if you have any questions on any of the slides or whilst we're going through any of the content, please do bob them up there because it may be quite a good talking point or something I can go through quite quickly. Hopefully answer some quick fire questions for you. If not, we can cover them at the end in a bit more detail. So let's just have a look at what we're going to be looking at today. So we're just going to have a brief overview of the role of the DPO, what your DPOs should be doing in schools. We'll have a look at Brexit, a bit of a hot topic at the minute, what this means for data protection and what's coming next. We're going to have a look at data protection by design and default and some new guidelines that have been issued for them and what this means for schools, again, what you should be doing. Code of practice to protect children's online privacy and why that's important for schools. Children's data in general, that's pretty much a given in education. Subject access requests, as it says there, the new hot potato. Everybody is now exercising their rights to obtain copies of their information, what we should be doing, how we should be handling that, and what we can do to protect schools and children, and having a look at the harm test, something that's really useful for the education sector that isn't commonly there or documented anywhere. So let's have a look at the role of the DPO. So in essence, your DPO is tasked with monitoring compliance with the GDPR and other data protection laws, your data protection policies, raising awareness, ensuring training takes place, and regular auditing. So if your DPO isn't doing all of them or isn't necessarily sure of what they should be doing with any of that, then you need to have a look at their job description. Now, there are guidance job descriptions available via the ICO website, as well for resources available online that you can use too. So your DPO should be giving professional advice, and it should be impartial advice as well. So that individual should be able to go to top level leadership in your school, multi-academy trust, the educational organisation, and ensure that they aren't blocked from doing so. They're there to question, to make sure that things are being done right and proper, and they should be questioning decisions that are made in relation to personal data, whether that be staff, governors, parents or children for that matter. They're there to ensure that data protection impact assessments are carried out effectively, and that's something we will be covering in later slides. So if you have any questions about them, because they are a bit of an unknown, as it seems to a lot of organisations, we can pick that up. If you're carrying out a DPA, you should be seeking advice from the DPO because they should be monitoring that process and overseeing it as well, and giving some useful advice in terms of weighting risk associated with those assessments. And ultimately, they're a point of contact for the ICO, so they should be cooperating with the supervisory authority, which, as we all know in the UK, is the Information Commissioner's Office. And if there is consultation needed as a result of a data protection impact assessment, in accordance with Article 36, the Data Protection Officer would do that on your organisation's behalf. So, in essence, the DPO has to have due regard to the risk associated with processing operations, so they should be fully aware and abreast of what goes on in your school, how you process data, how you manage data and how you store it, taking account the data protection principles, and as it says there, the nature, scope, context and purposes of the processing. So they should be fully affiliated with schools' processing activities and how they manage personal data. So, Brexit and data protection, what next? So, ultimately, we all thought the leave date for the EU was the 30th of January, but it's now being confirmed as the 31st of December 2020. So what this now means is that legislation, as it currently stands, as in the General Data Protection Regulation and the Data Protection Act 2018, will still remain in place as it currently stands without any changes whatsoever up until the 31st of December 2020. Now, the UK and the EU have ratified the withdrawal agreement, which does provide for a transition period, which EU law will remain applicable in the UK, as though we're still a member state. But that transition, as it says on the screen there, ends on the 31st of December 2020. So the UK has passed the European Union Withdrawal Act 2020, which will come into effect on the 1st of January 2021. And it is a statutory instrument to ensure that we comply with the current legislation up until that date. But from a data protection perspective, it just means that GDPR will remain in force until the end of this year. From the 1st of January next year, we don't know as it currently stands what that will look like. It's likely that GDPR and the Data Protection Act 2018 will remain in legislation, but it will become known as the UK GDPR as opposed to the EU instrument that it currently is. So what does this mean for us? Ultimately, not a lot at the moment, but what you can do and what we can use this time for is to go back through all your processing activities if you have any particular providers that you use, more specifically for online services. So there might be information management systems, there might be online databases, there might be system providers that you use, and it's prudent to go back through their due diligence information that they provide through their SLAs and their contracts and license agreements that they provide you, and make sure that where possible you find out where they are geolocated, i.e. are they based in the EU, are they based in the USA, are they based in the Republic of Ireland, and make a note of that, because it may be the case, unless we get an adequacy decision from the European Data Protection Board as a result of the ongoing negotiations with the withdrawal agreement, that you may need to implement or ensure that standard contract clauses are implemented into your license agreements and SLAs that you have in place with those providers. So it's certainly something to go away and check on. The ICO at the minute is quite relaxed. I mean, and in a recent briefing that they issued on the 29th of January 2020, they used the phrase, it is business as usual for data protection for now. So at this stage, we're not overly concerned. There's not much to worry about. And what we'll do is we'll just continue to do what we do. They will act as the lead supervisory authority for the time being in the UK, and from then on, we will just keep monitoring to see what happens from there. So, as I say, not a lot to do on Brexit for the time being, but we'll just watch this space on that one. And as time goes on, Fusion will be issuing more updates based on changing legislation and what else comes out from there. So, data protection by design and default, new guidelines. So on the 6th of January 2020, the European Data Protection Board released new draft guidelines on the obligations of data protection by design and default as set out in Article 25 of GDPR. Guidelines provide useful advice on the obligations, what they mean in practice, and how to implement the data protection principles effectively. So, what is data protection by design and default? So the principles of data protection by design and default require data controllers to ultimately implement appropriate technical and organisational measures and the safeguards necessary to protect people's data in accordance with Article 5.1. So what this means is that you're ultimately protecting the rights and freedoms of individuals as defined in the legislation, and making sure that you're not falling foul of those. So every time you start a new processing activity, you should be making absolutely sure that what you're doing is right in legislation, and making sure that you're not doing anything that is going to impede on people's rights, which is set out ultimately. So it must be implemented at the time of determining the method of processing and the time of processing itself. So this ultimately means that the data protection by design and default must be considered throughout the life cycle of your processing activities. So if you're starting something new, you might decide you want to process children's exam results in a different way. If it's likely to cause a risk to the rights and freedoms of a child or an individual for that matter, then part of your design process should take those rights and freedoms into account. So how would you overcome that risk? And that's where we also bring in data protection impact assessments. So if you have concerns about processing activities and how they might impact what you want to achieve as a result of that particular processing task, then you are obliged to carry out a DPIA, as it were. If the risk is great and it's something where you can't necessarily identify a measure to overcome that risk, then under Article 36 you're obliged to contact the Information Commissioner and begin consultation with them to assess the risk holistically and make sure that the processing is just not too risky that you can't do it. They are very helpful, they're also very efficient, so if you do ever have any queries, we'd always recommend that you do contact the ICO on anything. GDPR related, or at least make sure that you're continuously consulting with your data protection officer, because they should be there, and they are there to help you through those processes and manage them effectively. So the measures that you do put in place when you are designing your processing activities, they need to be robust, they need to be scalable, and what that means is that if it's the case where the processing activity or the amount of data you're processing is going to increase drastically, you need to be able to scale it up. So say you're a one-form entry primary school and you've got a limited amount of data which you can manage quite effectively in paper format. You might then decide that you want to move to a free-form entry primary school, and then you're trebling the amount of data you got. So actually you might need to look at a new way of managing things. So what that means is that you're designing a new processing activity. You might procure a new system, a new management system, and when you're designing that process, you need to account for the risks associated with it. So you'd need to think specifically about, is the system safe? Where's it located? Going back to the Brexit issue, can we account for those risks if they're based in America? Has the company signed up to the EU-US Privacy Shield? And post-Brexit, will it be a member of what will likely be the UK-US Privacy Shield as well? So those are the kind of things we need to be looking at, and what's going to help us. So in the main, what we need to be thinking about realistically is the amount of data we collect and what we intend to collect. So because really we shouldn't be collecting more than we need. The extent of its processing. So how often are we going to need to process it, what we're going to process it for, and what we're going to use it once we have processed it, and how long we intend to keep it. So what a lot of people miss is retention. And retention's a key issue, especially for schools, because you're tasked with looking after so much data, especially outcomes, to predict trends, in terms of children's outcomes and exam grades and things like that. You're often tasked with tracking whether boys are doing better than girls in a particular year, or is there a particular age group where people start to fall down and then they pick back up, all those kinds of things. And you've got to take into account whether it's more appropriate to pseudonymise those outcomes and just retain the figures as opposed to the full data sets, including all the personal details. And you've got to make sure it's accessible. So it should be easily accessible as well. So at the minute, the Information Commissioner's Office is currently working with the UK Accreditation Service to bring about some accreditation schemes, so organisations can start to look to become accredited and to make sure that they are doing what they say they do, bringing about the accountability principle. So to that end, that kind of sums up data protection by design and default. You could talk about that for days and days, but that's a bit of a whistle-stop tour of it. So, the Code of Practice to Protect Children's Privacy Online. Now, a lot of people think this is directly relevant to schools, and in part it is. And the Information Commissioner, Elizabeth Denham, said the laws to protect children in the real world. We need our laws to protect children in the digital world too, and that's exactly right, because more and more children are entering into online services. We see a lot of children who are starting secondary school, late primary school, using things like TikTok, Snapchat, Instagram. Some people are on Twitter and Facebook, and the Code of Practice in relation to children's online privacy is mainly to target those organisations and children's information society services to make sure that when they are allowing children to join up, that they are consenting to something that they're very affiliated with and they're aware of their personal rights. And in the UK, the age of consent is set at 13 for that purpose. So the Code of Practice sets out how the sites and the information services are designed and what kind of standards people should expect from them. In essence, what it requires is that a risk-based and proportionate approach to age verification should be carried out. Clarification on what services are considered to fall within the Code of Practice, because they're likely to be accessed by children. So if it's the case where it's likely that children are going to access your service, you need to take heed of this particular code. Ultimately, it's also there to support the ICO to ensure that effective enforcement action can be taken. And there's a lot of other information for the media industry as well. So in terms of the code, it was derived from the Data Protection Act 2018 to create world-leading standards. And how is this relevant to schools? Well, schools themselves use a lot of children's online information services. There's a lot of services and packages out there that schools can buy where children will regularly jump on them in lessons via online computers, or will use iPads, for example, and they'll be logging into things, they'll create their own accounts, and then there'll be potential learning outcomes as a result of them that are relevant to the curriculum. So that's fine, but what you should be doing, or what your DBO should be doing in accordance with other senior leaders in school, is carrying out the necessary due diligence checks and the necessary risk-based approach checks through the data protection impact assessment methods to make sure that that content that is on there is appropriate. So my advice would always be that if there is a particular online system that you're interested in, particularly for children in your schools, then really you should be asking for a full demo of all the facilities on there, all the things that it can be used for, and also what kind of information is collected from the children and how it's stored and where it's located. Because ultimately, there's the potential for them to put quite a lot of information on there, and if that can't be monitored in a way which the school would deem appropriate, then I would potentially move away from it. Because you need to know what's going on, you need to be able to monitor it effectively because you're using it for a very specific purpose. So, children's data. So we're moving quite quickly through these. As I said at the beginning, these are just some updates, so that there's quite a few subjects you could talk about, but I want to try and focus on some of the key ones for school and also kind of go through one of the major topics as well that I see most frequently as a school's DPO, and one that kind of, I suppose, creates one of the biggest headaches. So children's data, what we need to bear in mind, and this is a given, and you know, it's nothing new. It was in the Data Protection Act 1998, and schools have always been doing it, but ultimately there is an issue of accountability now and being able to demonstrate that you're managing children's data effectively. And it starts off ultimately with an appropriate privacy notice. Now, there's a bit of a misconception that you don't have to have privacy notices for children and that you can just lump it in with the parents one or just have a parent's privacy notice, where actually you do need one. Yeah, you need one for children and one that children can read and understand. And one of the ways I do recommend that you incorporate this into school life is through IT sessions and through computer sessions. And if you do have acceptable usage type agreements that you send home to parents to sign for the children, that you incorporate the privacy notice within that, so you know that every child has received it and they've had an opportunity to discuss it with an appropriate adult, and you could even run a lesson on it. In terms of age of consent, again, this is a misconception. If you think back to the age-appropriate design code that the ICO has issued, the age of 13 gets banded about quite commonly as the age of consent for children in general, which isn't the case. If a child is of an age where it can understand the information and the implications of what you do with their data, then say at the age of 7, 8, if it's a particularly intelligent child, they may be able to make a subject access request. So kind of the general things that we need to think about and we need to bear in mind, and some of these are taken directly from the ICO, and they are that we design our processing with children in mind from the outset, and use data protection by design and default approach. That's why we looked at that, and that's why we look at those codes of practice. We make sure that the processing is fair and it complies with the data protection principles. That should be a given in schools in general, and it should be a given in any organisation that processes personal data. As a matter of good practice, we use data protection impact assessments to help us assess and mitigate the risks to children. Again, bringing in DPIAs, this is why they are important, why people don't carry them out often enough. We have to consider whether our processing is likely to result in a high risk to the rights and freedoms of the children we look after and are in our care in schools. And again, DPIAs also giving consideration to consultation with the ICO. It's unlikely that you are going to carry out a processing activity in school which is going to put children's data at very high risk. But where it is at very high risk, we also have an exemption for that, which we will come on to. So as a matter of good practice, we take our children's views into account when designing our processes. So it is good practice, and not enough schools do it, to actually bring children into that. Give them quite informative sessions to talk about data protection, privacy rights, and what they can do, how they can protect themselves online, but also take some ideas from them as well. Get them involved. So in terms of your consent, as I said, there isn't really one in terms of subject access. If the child is of an age where it can ultimately understand what you're doing with their personal data, they're entitled to find out about it. The majority of the time, you are going to get a subject access request from a parent, so you are within your rights as a school to set the age of consent for subject access requests in education at the age of 16. If you wish, you might do it at the age of 13 if you're a primary school, for example, simply because up until that point you would quite like the parent to make that request on the data subject's behalf. However, if the children wish to exercise their rights and you feel that they would be able to understand the implications of doing so, then they are ultimately entitled to receive it. So the lawful basis is a given in schools, and you are carrying out a public task. So the lawful basis doesn't often change. We would only ever really use consent as a basis for processing when we are taking pictures, things like that, asking whether they can go on a website, all those kinds of things. But ultimately, you're processing because you're carrying out a public task. You are educating children on behalf of the country. So we don't often or even like to consider using legitimate interest or any of the other lawful basis. The others are more applicable to your staff. So if we're processing criminal data, for example, for so we can carry out an appropriate enhanced DBS check for a teacher or a member of support staff, we have the legal right to do so. And in many cases, we also have the right to carry out processing a special category data, because you have a right to protect children that are in your care. And the majority of the time when we are processing that special category data, we are carrying out that particular task. And just at the end there, DPIAs, I've said it time and time again, if you're ever unsure, you take a risk-based approach and you do carry out a data protection impact assessment. It's a risk assessment, just like any other that you would when you're taking kids out on a school trip. You're taking them down to the local woods, but you've got to walk them in a walking bus on the side of the road. You've got them all in high vis, holding hands. It's kind of the same for data protection, but it's just from a different viewpoint. You're looking at what are the risks by processing this data. Is it going to be easily accessible online? How many people have got access to it? Who's going to want to see it? We've got to limit those things and limit the amount of data we're taking in. So I just noticed that a question did pop up there, so I thought it'd be a good idea to have a look at that while we're on the subject. So let's have a look. So if a parent makes a subject access request and the child is over 13, do you still need the child's consent to pass that data over? What you should do, effectively, or what the legislation says, is you have to consult the data subject. So in that situation, it's more likely to occur in a secondary school, or if it was in a primary, it might be an ex-pupil that makes the request. Then ultimately you have to assess whether that individual is able to understand the data that you processed on their behalf. But if we take the secondary example, then ultimately, if the parent makes that request, you've got to speak to the child and just say, ultimately, are they aware, in essence, that their parent has made that request on their behalf? If they're not, then ultimately you do have to defer to the child in the first instance and make an assessment as to whether you feel that child is able to understand the implications of them having that data. Circumstances where that might arise, and it's not uncommon, is where families are estranged and parents who are no longer together. The child might live with mum, for example, and dad makes a subject access request. You would likely have to consult the child and the parent to, if there isn't a court order in place, safeguarding that particular area of information sharing, to check that they are both happy. It may simply be the case that the second parent just wants to know how the child is doing at school. They might have asked for the last 2 years' worth of school reports because the other parent's not willing to share them. And in essence, it's quite a legitimate request, and you would find it very difficult, as I said, unless there was any legal paperwork in place to prevent that request going forward, but you would always seek the views of the child in that scenario. Okay. So if you have any more questions like that, feel free to just pop them on the chat and we'll keep answering them. So that brings us nicely on to subject access requests. So what is a subject access request? I think we all know what one is now, but just to recap, it is a right under GDPR for data subjects to request a copy of all their personal data and all the information you hold about them or may identify them under GDPR and the Data Protection Act 2018. They can be made in any format, so they can be made in written, verbal format, they can be made by text, for example, and you've actually got to rely on the fact that your staff in school, especially the frontline staff, whether they be teachers, leadership, reception staff, admin staff, are actually able to identify a request and make sure that it's dealt with accordingly. So in some instances, it might be a parent that comes in a fit of rage, they say, I want a copy of all my child's data, I want to know what's being said about them. What the legislation says is that ultimately you do have to treat that as a subject access request and then track back. Because what you can't do is say to them, if you want to submit a subject access request, you've got to fill out this form, because legally you can't do that. So you would then say, in essence, thank you for that. You know, I understand you're now making a request for information to help assist us with processing your subject access request. Can I ask you to fill out this form to make it easier and for us to ensure that we try and comply with the legislative timescale associated with subject access requests, which is 1 month from the date of receipt. Now, the ICO recently updated their guidance, and what they said is that it used to be interpreted that if you weren't particularly familiar with the requester of the information, you could ask for identification, and then the clock started ticking once you were able to verify who that individual was. That has subsequently changed, been reinterpreted, and if you receive a subject access request on the 1st of February, for example, you have up until the 1st of March, but it's also prudent to try and get it in by the 29th of February, just to give yourself a little bit of grace. So, you're obliged to comply with the request unless there is a reason for not doing so, and there aren't very many reasons unless it's a vexatious request, if it's done to try and disrupt a process, or if it's one you've received more than once, for example, you've got the right to refuse. And upon receiving it, in best practice-wise, you need to acknowledge it and make sure that you let people know when those timescales are, but also let them know what due date they're going to receive the information, how they're going to receive it as well. Because what you're meant to do, if you receive it electronically, ideally is respond to it electronically. If not, you can go back to them and just say, look, I appreciate you requested it electronically. It's going to be much easier for us to deliver it in paper format. Would you be happy to receive it in that way? If they say no, there's not a lot you can do. If they say yes, that's great. When we're looking at what must be included, it's everything. There are some exemptions, which I'll cover at the end of these two slides that are just coming up. But every piece of personal data that you've got, you need to eke out and put to one side, and then once you've collected it all, start trawling through it. And when it contains personal data about third parties that aren't the data subject, you need to redact those. It may be the case that if someone is willing to consent, say it's an employee, they know full well the head teacher sent a communication, the head teacher's happy for their information to be shared as part of that request. You don't need to redact that then because they've consented to it. But if people won't give consent to their data to be released, then it's good practice to just go through and redact it all. So in terms of what we need to be mindful of, and we'll come on to that into the slide after this because it's extremely relevant to schools, and what can be exempted. So under Schedule 2, Part 4 of the Data Protection Act 2018, there are a number of exemptions that are relevant, but there's two particular ones that are very relevant to schools. One concerns HR, the other concerns employment in general, and then the third exemption, which isn't a listed exemption, is the one I will come on to. So in terms of the exemptions that are available to us, we have legal professional privilege. So the school, when it's carrying out its HR activities and its processing activities in relation to its staff, may from time to time need to seek legal advice. So that might be from an employment lawyer or another legal body. So you've got a caretaker who you need to move out of an on-site property because it's no longer sustainable. You might seek legal advice from that particular lawyer on how you go about that. So you're entitled to legal professional privilege. What the law says is ultimately that the list of GDPR provisions, as in subject access, do not apply to personal data that consists of information in respect of which a claim to legal professional privilege could be maintained in legal proceedings, or information in respect of which a duty of confidentiality is owed by a professional legal advisor to a client of the advisor. So you might go via your HR provider for legal advice. At the point at which a legal advisor or a legal entity becomes involved, it would generally be marked then at that point as legally privileged, which means that you're entitled as a client of that lawyer to be able to seek independent legal advice on any kind of issue you need to, and not have to worry under subject access that that information is going to be shared and released. Because there might be particularly contentious issues you want to discuss, and you want to be free to be able to discuss those openly with your legal bodies. The other one that is particularly relevant to education is confidential references. So, again, the provisions do not apply to personal data consisting of a reference given or to be given in confidence for the purposes of the education, training or employment, or prospective education, training and employment of a data subject, the placement or prospective placement of the data subject as a volunteer, the appointment or prospective appointment of the data subject to any office, or the provision by the data subject of any service. So, ultimately, employment references or confidential employment references are now exempt from GDPR and subject access. It used to be the case that people could request a copy of an employment reference. I think it was from the new employer. But now, since the implementation of the Data Protection Act 2018, that's no longer the case. You can't obtain a copy of them, which is helpful if somebody moves on. You've given an honest reference, which you're obliged to do as an employer, and then ultimately they don't get a job. You're not legally obliged to provide a copy of that reference moving forward. You're entitled to put an honest and accurate reflection of their time with you as a school. Can you charge for it? You can, but you can only charge basic admin charges. So what you can't do, in essence, is charge for people's time. So even if it takes you 40 hours a week for 2 weeks to process that subject access request, you can't charge the individual for that time. And how long do you have to do it? And can this time be extended? It can be extended by an additional 2 months, but that's in very limited circumstances. So it's the case whereby if it's a particularly complex request, you can do so, but that doesn't include scope. So if it's the case where you're in a large organisation, there's multiple departments you need to obtain information from, you can't request an extension on that basis. It needs to be that ultimately there's multiple requests all related to the same one, and they are all legitimate, and you need up to 3 months to process, say, all 3, for example, together. And do you have the right to refuse? I think I covered that right at the beginning. And yes, you do. You do have the right to refuse, but ultimately that's in circumstances whereby it's either vexatious, malicious, or you've received multiple requests for the same information from the same individual. So what the ICO says very briefly, we know how to recognise a subject access request, and we understand when the right of access applies. So again, if it's verbal, you need to know how to record that. We understand when we can refuse a request, and we're aware of the information we need to provide to individuals when we do so, and we understand the nature of supplementary information we need to provide in response to the subject access request. So in essence, you need to provide a letter when you send out all the information that they've requested, highlighting why it's been processed, what's it's been processed for, where's it stored, who's it shared with, and ultimately what's included within that subject access request, what exemptions you've applied, if any, and how long you intend to keep the data. And you've also got to give them the right to complain to the Information Commissioner's Office too. And as it says there, we need to understand how to comply with the request using clear and plain language. If we're disclosing information to a child, again, children have got to be considered as part of this. And we also need to understand if the request considers information about others and ensure that we do the appropriate redaction. So, the harm test. The Data Protection Act 2018 introduced safeguarding as a reason to be able to process sensitive personal data even without consent. What that means is, as a school, there was a bit of a misconception back on the 25th of May 2018 that you could no longer process children's safeguarding information in the same way as you had done previously. You can, and the Data Protection Act 2018 underpinned that and now safeguards that right for you as educational establishments. Schools can process safeguarding data without fear. Ultimately, have been prosecuted legislatively for doing so. So where does the harm test come in? So if we're carrying out a subject access request and there's quite a large amount of particularly sensitive data in relation to the safeguarding that child, it may be the case that the child is the subject of ill treatment at home or may be abused, for example, in school, under its obligations, records all that information accordingly and appropriately in whatever system you use, whether it's a paper-based system or you use one of the common systems like CPOMs, for example. The harm test would be applicable to subject access when that parent, say, makes a request because they suspect something's going on at school. What you would then do is gather all that information together, but you would ascertain whether it would be appropriate to send that information to the parent, because the likelihood is that it may cause harm to that particular child. And if the release of information is likely to cause harm to the child, then you're legally obligated not to provide it, because your safeguarding obligations override the rights to the parents to see what you record in school. So what would happen in that circumstance? Now, you can't state on your response letter to the subject access request that you have applied the harm test, because you're clearly identifying that you've got information that you want them to see. And there's also not an exemption that's actually applicable in law across GDPR or the 2018 Act that you can also note in the subject access response. So you wouldn't put anything. What you would likely do is receive a complaint or a complaint response from the ICO asking you to justify why you haven't provided any further information. And what you would in essence do is explain that you've applied the harm test, that subject access request, and the release of that information would likely pose a risk to that particular child, and as such you're not willing to provide it. So ultimately you're just fulfilling your safeguarding obligations as you would in written form, in addition to what you do day to day in school. It just becomes very applicable and relevant to subject access requests in general, and assists you in continuing to be able to process that information in the manner which is appropriate and a way in which is not going to prejudice what you intend to do, especially if you're working with third-party agencies such as the police and or children's social services. Okay, so that brings me to the end of just some of the general content that I put up on the slides there. As we said, it's a FAQs and question and answer session. So there's a couple of useful links there, some that I use on a regular basis. If you want any basic information, albeit we're hopefully well past that, the government via the .gov website has a continually updated data protection toolkit for schools. And if you do fancy visiting the statutory instruments themselves, then you can go to legislation.gov.uk or the GDPR/info.eu website to have a look at the GDPR legislation itself. And you can keep abreast on the ICO website of the latest news and what they've been doing. But you would hope that your DPO is keeping up to date with things and is there to answer any questions you may have. So I'll just open the floor up for any questions now if anybody's got any. So feel free to bob them up there and I'll do my best to answer what I can. Thank you.
Thank you very much, Ben. If anybody has any questions, can you just pop them onto the chat button? That's the second button in at the top, the little speech bubble icon. And we will look at answering those in due course as quickly as we can. One of the queries that we get a lot of, Ben, is about whether exam results being published is to be affected by the age of the person at any point.
Well, and again, it's one of them where, I mean, historically schools used to like to publish exam results, and you'd often buy a local newspaper where there'd be like pretty much every child that attended that school and then what grades they got. And again, we don't see it as much now, but it's also an issue of consent, because ultimately it is information about a particular child that's going out in the public domain. Now, I think the ICO has recently issued some brief guidance on this, but it will start to evolve. But as part of your annual kind of assessment of consent that you do with children, then what you can do is when they fill out those attendance questionnaires at the beginning of the year, if it's a secondary school, for example, one of the consent questions I would be asking is would you be happy for your child's exam results to be shared in local press and local media?
Great, that's lovely. Thank you very much for answering that. We've got a question here come in that says, if a child over 13 once informed about a subject access request disagrees with the information being provided to the parent requesting it, does this mean that you cannot share the information?
It's a really good question because it's very circumstantial. And I say it's circumstantial because you have to weigh up the rights of the child, being the data subject, against the rights of the parents to be informed about what is happening within the school. Now, if it's a 13-year-old pupil, for example, you might say that actually the child is of an adequate age to fully understand the implications of that information not being shared. The other side of that is that the parent might not be aware of issues in school, and the child is fully aware of those issues in school and is hiding things from the parent, which would actually aid the child at school, i.e. you want the parents to intervene in that situation, but they're not willing for you to share particular elements of the information. So you have to weigh up both sides. If it was, as I say, it's difficult in a sense because it only happens in certain circumstances. But what I would say is or if it was one of my clients, for example, I would certainly be asking the question, well, one, would the release of the information cause any harm to the pupil? Potentially likely not. And would the parent need to be involved in that particular situation or for a particular reason? If the answer to that question is yes, then you may decide as an organisation that actually the rights of the parents or the rights to the child's privacy are overridden by more pressing obligations from the school. And we go back to the safeguarding example quite a lot because it's extremely relevant. For you to be able to appropriately safeguard that child, you may need to share information with that parent to bring a more amicable outcome to a situation. So I would always look at it on a case-by-case basis. So it's not a carte blanche no, but if we take an older pupil, for example, and we take the estranged family situation, that child genuinely might not be happy with their information being shared with mum or dad or parent guardian, whatever the case would be. And in that circumstance, you would certainly take the views of the child into account, and the response to the subject access request may well be no. In every instance, you would give them the opportunity, if they so wish, to complain to the ICO. And I would much rather be having a conversation with the ICO as a data protection officer and justifying the decision making than you share the information and then it gets into the wrong hands or causes more problems. So it's always a risk-based approach in those circumstances.
Okay. And we just received another question, which is, we have a lot of pupils in special schools who would not normally understand the information in a privacy notice. Do you still have to make reasonable efforts to communicate the rights to those pupils?
The law says yes, but I also understand that there are real practical implications in that situation. So again, it's one of them situations where you have to try your best to get a message out there, but I also understand that in special schools there are also extremely wide-ranging variations in terms of need and what the level of understanding may be. And it might be a child, for example, who is on the autistic spectrum, who's extremely high functioning, but struggles very much with the kind of personal interaction and friendship side of the ASD disorder they've got, whereas you may have children who are quite severely handicapped, where realistically you're not going to be able to explain their rights to privacy. So in that instance, this is where communication, not just with the pupil, but with parents is key. And this is where I don't necessarily like the idea of combined parent-pupil privacy notices, but I do like the idea of an acceptable usage policy, which gives the opportunity for you as a school or an organisation to say, this is how we use data, we want your child to buy into that. But in this particular question, it would also provide the opportunity for the parent to become on board with how you process data and understand their rights and what you actually take into account when making those decisions. So I hope that answers the question. If not, please do come back with a supplementary question. There's quite a lot to consider in that particular one.
Okay, and a further question here. Do you need to do DPIAs on systems and processes already in place or just new ones?
So it's a question I do get asked quite a lot, actually, especially when I start working with a new school as a data protection officer. And what the law says is no, in essence, because you already carry out that processing activity. And really that was more of an issue back in 2018 in May when the legislation came about. If it's something you've done historically for a long time, you don't necessarily need to do one. But what I would always encourage, or what your DPO really should be doing, is regular reviewing your processing activities. And if there's no updated information that's been passed across for some time, then I would certainly carry out one as good practice, just to review what's going on with that particular processing activity. What it also creates is a database for you as a school, where you can refer back to if, for example, you were audited by the ICO, not that it happens to very many organisations, where you can say, yeah, we've done this for time immemorial, but we regularly review it. We regularly go back and revisit our DPIA. Nothing's changed with the system we use. We've just got a new set of pupils, and that's not really changed anything. But we're regularly assessing the risks associated with that.
Okay, and a further question here. We've created 2 notices, one for parents and one for pupils over 13. On reflection from what you have said, do you feel that this pupil one should be renamed to be an acceptable use notice or something similar?
No, I think I would certainly keep them as they are. I see no reason for you to amend them, but I think it is good practice, and it happens more so in primaries now than it does in secondaries. I would supplement both documents you've got with an acceptable usage agreement between, and in a lot of schools that I work with have a 3-way agreement. So it's an agreement between the school, the parent and the pupil, where all 3 of you are agreeing to buy into this kind of data protection framework, where you accept that you receive the data and you protect it, but when you're providing facilities for that child, that they respect that, they use it appropriately and proportionately, and you engage the parent in making sure that they're monitoring their child's online activities where possible, and just kind of upholding the principles that the school holds in terms of data protection and online safety as well. So it's something that you can use to engage parents in addition to your privacy notices, because lawfully under Article 13 and 14 you do have to have the privacy notices, but they're a supplementary thing, or acceptable usage notices, to really complement what you do and also shore up your accountability principle, in that you're clearly demonstrating that you're on board with data protection legislation and wanting it to be an integral part of how you process data in the school.
Okay, and let's looking at another question that's come in here. In terms of retention, do you recommend using the IRMF Toolkit as a basis of creating a policy?
So there's quite a number of toolkits out there, and ultimately it's one that's got to be right for you. So in essence, when you're looking at these IRMS toolkits, and I know that IT governance, for example, provide quite an integral toolkit, and there's a number of other organisations where you can buy in documentary packages. What they will do is give you guidance documents, but you will have to go through and carry out a lot of work in making them fit for purpose for your school. What I would always encourage, certainly when looking at these kinds of things, but also when looking at schools' DPO services, that the people you're looking at are educational specialists, because whilst a lot of organisations will offer DPO services, education is a very niche market, and to be a DPO in a school you also have to have school-based experience. You have to understand how schools work, how education works, the restrictions on processing, but also the right schools have to, almost disregard in some instances, GDPR and the Data Protection Act to achieve your legitimate aims, which ultimately is to protect children. So it's not one that I can realistically answer in that I would recommend a particular one. What I would say is that you really need to do your research, and you really need to look at what's out there and whether they offer any support in addition to the basic toolkit for schools.
Okay, and a further question here. In terms of auditing in schools, how often do you recommend completing these, and what would you suggest should be the main focus within schools?
Okay, so it's all relative is auditing, because I might say you need to audit once a month. Someone else might say that you need to audit once every 6 months, and I know unfortunately some DPOs audit once a year, which isn't very helpful for that school, because you have large amounts of information coming in on a daily, weekly basis that will often change the amount that you have. The biggest area for me in schools, which I think often gets missed, is retention, because schools for some reason have a habit of retaining pretty much everything they've ever brought in. And it's been assisted with the introduction of electronic-based systems, online and cloud-based systems, but schools seem to have quite a significant amount of paper-based records. So in terms of auditing, one of my focuses in particular is asking to see where all this information is stored, how much is stored, and how long they've been keeping it. The Information Records Management Society have a template retention schedule that schools specifically can download. And what I would always recommend is that even if you don't already have a retention schedule, you go download that one and you start working through what you've got in school. And if it's outside your retention deadlines, you start disposing of it securely. Other areas to focus on in terms of auditing are more your electronic-based systems now, as everything is moving to an online cloud-based system, but also revisiting and looking at your contracts that are in place as well to make sure that they're fit for purpose and they're Article 28 compliant, so you're fulfilling all your obligations that are in law. But regularly review your policies, make sure your privacy notices are up to date. When things are changed, that you make sure you revisit your privacy notice. You might change an electronic provider, for example, for staff. You might have to go back and change your staff privacy notice. So just looking out for those kinds of things and just keeping on top of it. So it's in effect a constant auditing programme, but in terms of formal audits, I would at least say once a term internally, and then externally maybe once a year.
Okay. Moving on, we're going to look at should you keep copies of the same information electronically and on paper, for example, staff files and pupil files?
Ultimately, it depends whether you need it. So you might decide, it might be a children's safeguarding investigation in relation to a member of staff, and the reality is it may be that there's a lot of handwritten notes that are then scanned in and kept electronically. The question always is, do you need both? And in reality, the answer may well be no. And if you don't need them both, then I would probably defer back to the electronic option, because it's easier to manage, it's easier to organise, and it's easier to file, and you don't need masses of space in a room or shelving or physical storage to actually keep hold of it all. One of the things I often recommend to my schools is that paper-based records that they do intend to keep, I always recommend that they do scan them in, PDF them, password protect them if necessary, and then store them in an archive file online. Because when it comes to destruction, they're actually much easier to get rid of and record when you do it electronically, as opposed to physically doing it and using someone like Shreddit to come in and actually take away all your physical data waste.
Okay. And the final question, do you have to record what you have destroyed in terms of retention?
Well, technically the legislation says you do, but unfortunately not many people do. And the reason it's important is that if you get a subject access request and it's a particularly contentious one, and you're going back to a data subject and saying, well, we no longer have that piece of information, the question is, well, why have you no longer got it? And you need to rightfully be able to say, well, actually, in accordance with our data retention schedule, we only keep it for 2 years in this particular instance, and as such, it's deleted on or destroyed on X day because we sent it off to Shreddit like we do with all our confidential waste, and they then physically destroyed it. By the way, I'm not advocating Shreddit, it's just the only secure data destruction business I could think of just at this point in time. So, in essence, yes, you do realistically need to, because when you go back and auditing, and you're actually checking your retention schedule against what information you have, you need to be able to say, yes, actually we have deleted that, and we deleted it on X date at X time, and it was done via an electronic method, or it was done via a physical method, but it was done safely and securely. So then if anyone does ask why you don't have that information, you can sit back and say, well, it hit our retention schedule deadline, and we destroyed it in accordance with that procedure.
Okay, are there any further questions before we close the webinar? I'd just like to say thank you for Ben for going through all that information and answering the questions. We hope you found it useful. If you do have any questions off the back of this webinar, please do get in touch with us at Fusion HR. We'd be happy to help you further if you need to. We do as I said at the beginning, offer support for schools in terms of DPO support, auditing, and indeed policies. And if you feel that that can help, then do have a look on our website or give us a call. Thank you very much for joining us.